Welcome to Bed Crime Stories podcast. I'm your host, T. Good morning, good afternoon, good evening, bed crimers. As always, I wish you the best. To anyone new here, a warm welcome. Thank you for checking out my channel. Let me just ask that after listening to or watching this video, if you learned something or enjoyed it, please do me a favor and smash that like button. Now, let's dig in. T here with a bed crime bite. It appears that survivor Bethany Funke was issued a subpoena to appear as a material witness in the case of the state of Idaho versus Bryan Kohberger. What is interesting is that Bethany, through her attorney, has asked to have the subpoena quashed. What does that mean? Here is a definition of this from legalmatch.com. What is a motion to quash? A quash definition would be to reject or void, especially by a legal procedure. Simply put, it is a verb meaning to put an end to. A motion to quash refers to a specific type of request in which one court is asked to render the decision made by another lower court as invalid. A motion to quash example would be if a party experienced improper service of process. They may decide to file a motion to quash. Either party may file a motion to quash. As previously mentioned, a motion to quash is generally requested as a pre-trial motion when a lower court's decision has a direct effect on the case currently being heard. A pretrial motion is a document that is brought before the trial formally begins. It must be specifically requested in order to take effect. Additionally, pretrial motions commonly have strict filing deadlines and will be considered waived if they are not raised within the appropriate time frame. A motion to quash may only be filed when 1. The court has made some sort of mistake in their ruling, and or 2. A court document such as a subpoena has been issued in such a manner that it is considered to be illegal or improper. Here is how a person files a motion to quash a subpoena. Once again, the most common motion to quash is a motion to quash a subpoena. When a party receives a subpoena for documents, to appear for a deposition, or to testify at a hearing, the easiest option is to comply with the subpoena. Alternatively, the party subject to the subpoena can file objections or a motion to quash, which is what Bethany Funke is doing. Common grounds for filing a motion to quash are that the individual is outside the subpoena range, or that the items to be produced are unavailable within the specified time or at a specified location. Other grounds for filing a motion to quash include undue burden and expense. So I'm thinking perhaps Bethany, who has probably been severely traumatized by this entire event, probably does not want to appear in court near Bryan Kohberger. I mean, she would probably be terrified by his presence and not want him to be able to lay eyes on her in person in that manner. Perhaps she's arguing that she didn't really see anything on the morning of the attack, during the hours of the attack, and that she has little to offer from that perspective. And perhaps she's saying that the trauma of appearing far outweighs any value that she could add. I'm hoping that people don't attack her right now for this, because we don't know what she's going through, and it's not our place to say, well, she's not going because she doesn't want to help or she has something to hide. It will be interesting to see if Dylan Mortensen also files a motion to quash her subpoena, because there's absolutely no doubt she will be subpoenaed. That's all for this Bed Crime Bite. I hope you guys are all well. Until the next time on Bed Crime Stories.